First of all, thank you very much, Catherine and Sebastian, for your very insightful overview presentations on the DSA and the DMA. My name is Nina Thomic, and it is now my honor to moderate our first main session of today, during which we will mainly focus on the proposal for regulation on contestable and fair markets in the digital sector, the Digital Markets Act. Our first speaker in this session is Alexandre de Streel. He is a professor of European law at the University of Namur and the Research Center for Information Law and Society. He is also a Hauser Global Fellow at New York University Law School and visiting professor at the European University Institute, Sciences Po Paris, and Barcelona Graduate School of Economics, and also assessor at the Belgian Competition Authority. Furthermore, he is academic co-director at the Center on Regulation in Europe. His main areas of research are regulation and competition policy in the digital economy, as well as legal issues arising from digitalization. Dear Alexandre, we are now looking forward to hearing your presentation. Thank you very much.
Hello, good afternoon, everyone, and thank you very much for the invitation. So I will share my slides. Okay, I'm not sure I can share it on this screen.
You should be co-host by now.
Ah, yeah. Okay, perfect.
Brilliant.
Okay, so the idea, we divide the work between Alexandre and Alexandre in two ways. So I will deal with substantive issue, and then my homonyme will deal with the institutional issue. But in both cases, we will try to answer the question which was asked. Is the DMA a revolution or an evolution? And so to do that, first, I would like to understand why we have the DMA, because, you know, many people ask this question, but why this pressure to do something and so on? And it's always good to cite George Orwell in a digital conference, which is said, I often understand why, but I do not understand. I often understand how, but I do not understand why. And really that is a difficult issue. So my take is I can see 4 reasons why there is this political pressure, as the minister was recalling, to do something with digital platform. And you could see all those reasons which are complementing each other to create a virtuous circle for regulation, or I guess the platform will say it's a vicious circle, but whatever. The first reason, I think, is some say it's a kind of protectionism, to protect either EU firm, because it's true that most of the platform which will be regulated by the DMA today are not European, or to protect the loser of the disruption. When I talk about loser, my point is not to have a moral judgment, obviously, but as always, when you have a disruption, some people lose, other gain. You know, and you may think that the loser will try to lose less by using regulation. Okay, and a loser can be very powerful, as we have just seen in Australia. So the second thing is concentration. Clearly, and I think it has been mentioned before by all the previous speaker, we see a concentration of economic and innovation power among very few players, and that is raising some issue. The third reason why we have this DMA and more generally the platform regulation is that many believe that there is a kind of unfairness there, because it is true that those platforms have create a lot of added value, but they seem to keep most of the value for themselves, you know, and in particular because the digital taxation, as you know, is relatively low. Hopefully some progress will be done, and with the new American administration, this is expected. But up to now, I mean, it seems that the result is still unfair. And then the last, and I think probably the most fundamental reason why we have this pressure to do something is that there is either a perceived or a real, but in politics that doesn't matter so much, of loss of autonomy. So I think that citizen, user, business user, and state themselves have the feeling that they lose autonomy, and to take what Johnson was saying, they want to take back control to some extent. And I see that this process of regulating the platform is a way to take back control. Now, I think we have to have all those reasons in mind to understand what is happening in Brussels and in Strasbourg, and maybe to try to influence the process for it to evolve in the best way. Now, I will go through each different step as it has been done by Catherine before, and give my own opinion on the DMA proposal. So first, regarding the objectives are very clear. I mean, there are three objectives. One is the first one is to ensure the contestability of the market, which to some extent is a sort of ex-ante fairness or a level playing field, And there, the idea is to ensure a long-term efficiency. And by doing that, hopefully the size of the pie will increase. Okay, the size of that value will increase. But what is interesting, I think, with this contestability objective is that clearly we favor long-term over short-term. And by doing that, we are reversing a bit the recent tendency of competition law, which has tended, I think, but okay, we can discuss that, to favor short-term over long-term. The second objective, and it's linked to one of the concerns I was mentioning before, is to ensure that there is more fairness, in particular between the gatekeeper and their business user. And that is an ex post fairness. It's more a distributional issue than an efficiency issue. It's more related to the division of the pie than the size of the pie. That is a little bit more controversial because we don't all have the same view on what a good distribution is, and I guess that the heterogeneity of preference across the member states of the European Union are higher than regarding efficiency. And this is why, in fact, in Europe, this probably would be one of the first B2B fairness law. We had a directive before, which was adopted 2 years ago regarding farmer and supermarket. But this is one of the first B2B fairness law that is appearing. And then the last objective, as it has been mentioned before, it's the internal market. We want to have the same rule for what are global players. Okay, so those are the objectives, and broadly, I think they are right. My only, let's say, concern is how this fairness objective will be interpreted, because, as I said, it can be interpreted very differently and lead possibly to some regulatory creep. The second question then is the intervention bar. At which bar and how high the bar it is for the regulator to intervene. Now, this is, as you may know, the world champion on vault jumping, but I hope the bar will not be that high for the regulator, otherwise only one could pass it. But the point is what they have to prove. And there, I think it has been extremely well explained by Catherine before, so I can be quick. There is 8 digital services, which are called core platform services, which are pre-selected in the law. You may have noticed that most, but not all, are information society services, and so fall also under the e-commerce directive. Now, why those 8 digital services have been selected and not others? And there, the Commission is more or less clear in recital, but not directly in article of the proposal. It's because that's where you have the highest probability to find a gatekeeper. That's where you have the highest probability to find a problem, because there is high entry barriers, networks effect, dependencies issues, and so on. Okay? And then the second issue is the gatekeeper. And there, Catherine explained the 3 criteria that will be used, that are used by the proposal to define what is a gatekeeper. First, and it's 3 cumulative criteria: significant impact on the market, on the internal market. Second, you are an important gateway to reach end user. So People have to go to you. That's the idea of a gate. And third, this position is entrenched and durable, because we know that those markets are very dynamic. So it's very important that we have this time dimension in the analysis. Now, what is interesting and clever, I think, in the proposal is that the proposal make a number of set a number of size thresholds, so very quick, easy to determine size threshold, which would create a rebuttable presumption that you are a gatekeeper. Okay, so if you meet the financial and geographical size and user size criteria, which are mentioned on the slide, I will not go through all of them, but basically you are a big company with a lot of users, then you are presumed to meet the 3 criteria test of gatekeeper and being a gatekeeper. The thing is that we know that size is not necessarily linked to a gatekeeper, because you may be big, but if you are in a very, very big market, you do not control a gate. And so the platform will be able to rebut the presumption of gatekeeper if they show a number of economic criteria. And there in the quantitative and qualitative indicator, which can be used by the platform to rebut the presumption, are, I think, what the economic theory tells you about what is a gatekeeper or bottleneck. Okay, so it's related to the size, but it's mostly related to the fact that your users are depending on you, that they are locked in, and that a competitor cannot arrive because there is a lot of barriers to entries and network. So I think the criteria, I mean, the system is quite clever, because it's creating a rebuttable presumption, which is easy to do for the commission, the size threshold, and then it's up to the platform, which have most of the information, let's remember, to rebut the presumption if they think that they are big, but they are not a gatekeeper. So a very good system. My only concern is that, given the fact that the gatekeeper is a new concept in the European law, and that there is a long list of economic criteria that can be used by the platform to try to rebut the presumption, it may be good to have some guidelines to know how those criteria will exactly be used. Because it's very well to have an open list of criteria, but then what does it mean in practice? I think there we are a bit. It's not clear. Now, on the other hand, this legal uncertainty is inevitable. Every time you use new concept, you create a legal uncertainty at the beginning, and I think it's good to use new concept here because we have new problems. Okay. Then let's go to the next part, which is the kind of the new commandment. You may remember those 10 commandments, and now we have the 10 commandments of the ancestor of Breton and Vestager. Now we have the new prophets of Europe, which have 18 commandments. So they are even more ambitious than Moïse was in that, they have presented those. And if you go to those 18, you see that there is a true list, a blacklist. So this is really detailed and self-executing, and a gray list, which is a little bit more general, and therefore may need to have some specification, need to be specified by the Commission. Now, I will not go through all the list. What I have tried to do here is I have tried to organize those 18 commandments into 4 theory of harm, or 4 problem, harm to contestability or to fairness. Okay. So the first theory of harm is transparency in ad intermediation. As we know, ad tech is an issue, has been investigated by several authorities across the world, and so clearly more transparency is in need there. But I think that is really, not much. I mean, it's just transparency. What is really interesting, I think, is the second and the third theory of harm, which are related to every. The second theory of harm is more on the supply side. It's all behavior, conduct by a gatekeeper, which either try to envelop a competitor, a smaller competitor, through bundling and self-preferencing, and by doing that, you try to put your competitor out of the market, or refusing access to the platform, your platform and your data for a complementary product. okay? And you make the life of your complementer, of your business user, more difficult, okay? So that's more behavior which are related to the supply side, and then and which are limiting contestability of market. And then the third theory of harm is more related to more behavior on the demand side, which are limiting market contestability. And this is really related to all a number of conduct which try to limit the mobility in the sense of switching or multi-homing of the end user and the business user of the platform. So really the goal here is to prohibit every behavior which try to limit that mobility, okay? And then finally, the fourth theory of harm is really the some unfair practices, like for instance, refusing access to App Store at front condition. Now, what is interesting, I think, is that you could see that most of the practices, most of the commandments relate to the second and the third theory of harm, so which are around contestability. So clearly fairness is an objective, but I think that if you look at the commandment, the focus is really on the objective of contestability more, I would say, than fairness. Now, something maybe to improve, I think the regime, as many have already said, which have commented on the DMA proposal, the regime is a little bit, and it's strange because it's very rigid when you see the recommendation, the 18th commandment, the obligation, sorry, the 18th commandment, and then it's very open because the Commission may add new commandment, new obligation after a market investigation and with a delegated act. So to apply the existing obligation, the Commission discretion is very much constrained because the text of the law is detailed, but then to add new obligation, the power of the Commission is not constrained at all because they can add every obligation which would increase contestability of fairness. So in a way, you know, we are in a too extreme system, and maybe I would have preferred, no, I understand why we have detailed rules because they are easier to enforce. But instead of having this very broad possibility for the Commission to, let's say, to add new obligation, and after 2 years, I would have preferred to have a kind of more flexible, more principle-based interdiction, like, for instance, to prohibit, next to the black clause, to prohibit every conduct which tends to limit the mobility of users, you know, and to have a bit like what we have in the Unfair Commercial Practice Directive, you know. You have a series of blacklists now of nearly 40 clauses now, which are detailed clauses of unfair, aggressive practices or misleading practices. But then in the directive, you have a more generic definition of unfair, misleading and aggressive practices. And maybe we could be inspired in the DMA by this system. The second thing is that all the obligations apply to all the gatekeepers. So there is a kind of one-size-fits-all. No, I mean, that's a bit superficial view because it is true that there is some possibility to specify some obligation. And in doing that, an individualization is possible. And also some obligations are very much core specific to a particular core platform services. So there is an individualization which is implicit in the law, but I think it could be stronger and more explicit. Okay. The second thing which I regret is that there is no possibility, not at all a possibility, for the gatekeeper to bring with a defense. So to show that their behavior at the end of the day do not harm contestability and or fairness. So it's not the same as an efficiency defense under competition law, because the objectives are not the same. But still, I think it would be good to have this possibility of defense, which is not there. And the second thing which I regret is that the Commission could not decide not to apply one of the 18 commandments to a specific platform if it is not justified. So, you know, a bit of more specific individualization would be in need here. I mean, we have something in the law, so I'm not part of the brigade who say that the Commission was completely wrong because it's a one-size-fits-all system. I don't think it is, but I think more individualization may be needed. So finally, what are the policy choice behind, you know, and here I want to refer to another big intellectual of the last century, Walter Eucken, who was one of the founding fathers of the ordoliberalism. because I think that the DMA is very much in line with the ordoliberal tradition of Europe. But more generally, I think most of the policy choices which have been done in the DMA are relatively traditional for Europe. You know, it's using sector regulation as a complement when competition law policy cannot do the job. It is favoring long-term over short-term, and by doing that, favoring user choice and autonomy, and what you call self-determination. But you know, if you think of it, self-determination and take back control is the same thing. Right? One is more politically correct than the others, but it's very close. It's to use behavioral remedy instead of structural remedy. So, and it's what, for instance, what has done in many, in most, not all, but most network industry. It is using, in this debate between rule versus discretion, as I said, I mean, here the DMA do a bit both, because it is detailed rule for existing obligation, but then large discretion to add new obligation. And then, Alex will talk about that later, it is going for a centralized enforcement over decentralized. So at the end of the day, do we have a revolution here or not? Because that's the question we were asked to answer. And their answer is, as always, mixed. Yes, the DMA as such is a revolution because it's the first time that we have an asymmetric EU law on online platform. Most of the previous law, the GDPR, the platform to business regulation, are symmetric, and I think that's a problem. So I think it's good. This is a revolution, but this is a good revolution. But on the other hand, this revolution is based on very traditional choices. At the end of the day, you know, very traditional choices. So you remember this saying, maybe everything needs to change for nothing to change. But maybe we are there, you know, in the sense that yes, we do a revolution, but on the basis of very traditional choice, except maybe on enforcement. But then the next speaker will develop that. Thank you very much.
Thank you very much, Alexandre. I'm sure all conference participants are very much looking forward to discussing some of the aspects you just mentioned in your speech later on in a round of discussion, which we'll do after the speeches are completed. We are now moving on to our second speaker of today, Alex Ruiz Feases. Alex is a postdoctoral researcher in competition law at the Department of Law, Technology, Markets and Society at Tilburg University, and also a senior member of the Tilburg Law and Economics Center. His research mainly focuses on European Union law and in particular EU competition law. As this is one of his main research interests, Alex will be focusing his presentations on the enforcement issues related to the DMA. So Alex, I would say the floor is yours.
Yeah, thank you very much, Nina, and thank you for having me here. It's a pleasure. So yeah, I will. My presentation follows up Alexandre's presentation on substantive issues, and I would like to focus on some enforcement points. It was very nice that Professor Vanderhorst said at the beginning that the University of Vienna focuses on, it's always asking the right questions. And actually, I had planned to start my presentation by answering the nice question that you asked in the conference, which is the digital services package, in this case the DMA revolution, is more of the same. Now, I would like to say my answer from the outset, which is yes, it's a revolution in my view, but it can be improved when it comes to certain issues of enforcement. So I would like to talk about three particular points. One is about the instruments that the European Commission has. The other is more about remedies. And then finally, from a perhaps broader perspective, about consistency of the DMA with the enforcement of major control and also competition law. So you've done also a very nice presentation of the overview of the DMA, perhaps looking at the main decisions that the European Commission can take in greater detail. Here's a sort of map that I've been trying to do. I've put aside the market investigations that the European Commission can or could conduct. But here you have at the top the main decisions that the European Commission can take, and then some complementary decisions. So in the main decisions, what we have is Article 7 decisions, which is when gatekeepers have not complied with the that is under Articles 5 and 6. And the consequence here is that the European Commission can impose specific measures. And Article 7 essentially what establishes a sort of a framework for having a regulatory conversation with the gatekeeper. So they can finally say, okay, this is the way that you should comply with the obligations more effectively. Then we have Article 25 decisions, which is non-compliant decisions if the gatekeeper has not complied with either Articles 5 or 6, with Article 7 decision, with Article 16, I will be talking about that in a minute, Article 22 and also Article 23, which are about interim measures and commitment decisions. And here, essentially, the consequence is that the European Commission will issue an order to cease and desist with the non-compliance and also recommend some measures. And this is the way that I read Article 25, paragraph 2. And then also can impose a fine up to 10% of turnover, and the details are in Article 26. And then what we have is Article 16 decisions, which are decisions when in situations where we have systematic non-compliance. And here we need two cumulative conditions. One is we need a systematic infringement of Articles 5 or 6, and that what we have is we need at least three or more Article 25 decisions within 5 years. And also the gatekeeper should have strengthened its dominant position in the market as a result of the non-compliance. And here the consequence is that the European Commission can then impose behavioral or structural remedies. So this is more or less the main decisions that the European Commission can take. And then in the interim of these procedures, the European Commission can also take interim measures decisions during Article 25 only. And here what we need is prima facie infringement and also a serious and irreparable damage for business users or end users of gatekeepers. And then we have commitment decisions within Articles 25 and Article 16. Now, the reason why I've been putting this is just to discuss a little bit all this enforcement toolkit that the European Commission has. So, for example, one question is, okay, do we need all this? Is all this necessary? So I'm going to exaggerate now. Please just, my intention is just to spice up a little bit the debate. But think of this situation. Imagine, for example, that we have a gatekeeper that does not comply with effective measures, does not implement effective measures to comply with Articles 5 or 6. So then the European Commission will issue an Article 7 decision, which is this one here. Then say that the gatekeeper does not comply with Article 7 decision. So then the European Commission will go to Article 25. That's one of the situations that we have here. Now, say that the gatekeeper does not comply with that Article 25 decision. So the European Commission can issue more and until you have a systematic infringement. So finally, you have an Article 16 later. So we are in this situation where the gatekeeper has already an Article 16 decision. And then the European Commission, if the gatekeeper does not comply with that decision, the European Commission can issue, and again, another Article 25 decision, right? This is the situation that we have here. So the question here is, do we need all this? Is it not too much in order to make gatekeepers to comply with the obligations? So here I have 3 solutions. So one solution would be to issue a joint decision under Article 7 and Article 25, and that way you will simplify the whole procedure. Why? Because, for example, Article 25, it's about recommending measures, but under Article 7, you can impose specific measures. So if you combine both and you issue a joint decision, maybe you can get the best of both worlds. So that would be one. The other would be to eliminate the possibility to go directly to Article 25 if there is an infringement of Articles 5 and 6, which is this situation here at the top. Now, why I'm saying this? Because I guess that the idea of the European Commission here is to have a sort of pyramid of enforcement, right? So you have first Article 7, which is a sort of soft decision where you have a conversation or dialogue with the gatekeeper. And then if the gatekeeper does not comply, then you go to Article 25. Now, the problem here is that there is a sort of redundancy because you could go to Article 25 directly if there is an infringement of Articles 5 or 6. So maybe, you get rid of that premise, and then you have your pyramid more coherently. Now, the other solution that I could think about is just to get rid of Article 7. You already have Article 25, and what you could do is to allow the Commission to impose more specific measures here under Article 25 instead of having Article 7. And that way you simplify. You only have two type of decisions, Article 25 or Article 16, and that's it. So that would be a way of simplifying all this. Now, this is more about the instruments in general, but if we look at the specific complementary decisions that the European can take, on the one hand, we have interim measures, and on the other hand, we have commitments. Now, the question is, okay, are interim measures here useful? Because the purpose of interim measures, for example, when we're talking about competition law, and there we have Article 8 of Regulation 1, is that it allows the European Commission to intervene quickly with some temporary measures until it reaches a decision. Now, the DMA is quite quick or quicker than competition law. So does it make sense to have here interim measures? My answer is that yes, it makes sense. And I think the European Commission here has been quite smart in the way that it has designed interim measures under the DMA. And the reason why I'm saying this is if we compare both. So for example, interim measures under Article 8, there you need an urgency due to the risk of serious and irreparable damage to competition. And then also you need a prima facie infringement. Now, the difference between the two is that on the one hand, you have that the damage has to be to competition, and under the DMA is to business users or end users. I think this is smart because I think it's easier to demonstrate a particular harm to business users or end users rather than to demonstrate at the beginning of an investigation harm to competition in general, say, for example, market foreclosure. But it's more, I think it's easier to demonstrate that one competitor is being excluded, is being foreclosed from the market, rather than demonstrating the whole harm. And then you continue the investigation. So I think Article 22 in that sense is it's quite nice. Also, in the context of the DMA, you already have Articles 5 and 6 that contain a list of obligations, as Professor Streel has said before, and that you already have your prima facie infringements, whereas under Article 8, it's more tricky to demonstrate. And also the problem with Article 8 is that the European Commission later has to demonstrate that there is a theory of harm, dominance, etc. Whereas here in interim measures under the DMA is more simple. So I think it's a smart choice. Now there are a few things that could be improved here. So one, for example, is that interim measures can only be applied in procedures under Article 25, but not under Article 7. Now, Article 7 creates that regulatory dialogue, and maybe there it's a good idea to have already interim measures, because if at the beginning, if the gatekeeper is reticent to dialogue, then you can impose, for example, behavioral remedies, and then in the interim, then you can sharpen those remedies that you have already imposed under interim measures. So maybe a solution there is to allow also the Commission to impose the interim measures there. Now, the other tricky issue here is that it's only applicable to gatekeepers. That's what the Article 22, paragraph 1 says. And now the problem is if the notion of gatekeeper is litigated. So there, for example, that can delay the intervention of the European Commission. So maybe the concept of gatekeepers there could be just taken out. And then the other thing is that Article 17 allows to conduct market investigations to implement, to find out new services practices that could be legal. Now, this investigation can take up to 24 months, and there maybe you need also interim measures. However, interim measures are not conceived to be applied there, so maybe also that could be improved. And the other point is the legal standard of serious and irreparable harm. So now there is a trend at the national level in competition law to change that legal standard. So for example, the UK, now the National Competition Authority in the UK can impose interim measures if necessary to prevent significant damage, but there's no need to demonstrate that damage would be irreparable. And then also in the new German competition law, interim measures can be applied if there is an imminent threat of serious harm to another undertaking. And that lowers a little bit the legal standard to impose interim measures. So maybe here the European Commission wants to polish the way in which Article 22 has been designed. Now, the other thing is about commitments. We already have commitments. We have experience there in the case of competition law. We have Article 9, and their undertakings can offer commitments after a preliminary assessment of the European Commission in a case. And there's no finding of infringement. There's no infringement established by the European Commission. It's just a preliminary assessment. And for this reason, the commitment decision is not binding for courts. And here we have a case issued 3 years ago by the European Court of Justice. And Nonetheless, even though they are not binding, they can foster private enforcement, because if you're a private litigant and you have already a preliminary assessment, you have already of economic investigation there, and then you can bring your case to the court. Now, when it comes to commitment decisions under Article 23 of the DMA, the gatekeeper can offer commitments. However, it's not very clear whether these commitments will be binding for courts, because these commitments will be based on Articles 5 or 6, where you already have a list of conducts, let's say, that you consider are anti-competitive, let's say, using the vocabulary of competition law. So kind of make these commitments almost binding for courts. And then, so here the question is how these commitments are going to affect private enforcement. And also, perhaps more importantly, is what is the difference between these commitment decisions and the other decisions that the European can take? For example, Article 7, Article 25, etc. It doesn't seem that there is much added value of these commitments within the DMA. So maybe the European Commission just wants to get rid of these commitments. Now, about remedies, just a few words here. I think the DMA is very smart because it's given them a different dimension that we have when one thinks about remedies in competition law. So in competition law, normally remedies are the end of the road. So you have a market investigation, you have the European Commission establishing dominance, etc., theory of harm. Then you demonstrate that there is harm or actual or potential effects. And then at the end of the road, you have the remedies. Now here, if the one way of reading Articles 5 and 6 is by looking them as a sort of codification of remedies, because actually if you read recital 58, there the European Commission is saying, or the DMA is saying, look, and the gatekeepers need to change their technological design, which is their DNA. So in that way, the fact that gatekeepers have to comply with the obligations under Article 5 or Article 6 makes these articles already a sort of codification of remedies as well. So I think that choice is very interesting. Now, the thing, two thoughts here is this. What is the purpose of remedies here? Are they punitive? And I'm asking this because the European Commission can only impose behavioral or structural remedies at the very end. So when it comes to Article 16 decisions, once you have systematic non-compliance. Now, if the purpose of remedies is to make markets more competitive, and there is a structural problem in the market, maybe you want to impose structural remedies earlier, not at that stage, after a systematic infringement, where you need more than at least three decisions under Article 25, etc. So maybe this brings me to my other point. The DMA is a bit too shy when it comes to remedies, right? And actually, it's quite surprising because for example, in merger control, structural remedies are quite often a way to clear mergers. So there is a sort of fear here about imposing structural remedies at an earlier stage that I wasn't expecting when the Commission was working on the DMA. And then also another point is what type of remedies could the European Commission impose via interim measures? That's not clear from the DMA, and maybe one wants to think a little bit about that. Perhaps only behavioral, because they are just temporary and you need to reverse them. So structural remedy there maybe not very useful, or maybe too strict, but still the European Commission should clarify that. And then maybe just a few words about consistency, and I will stop there. I think it's nice that the DMA is connecting, is making a connection with merger control. And Article 12 requires gatekeepers to notify intended concentrations, or once the concentration has been already celebrated but not implemented yet. And these two obligations are in Article 12. And I think this is consistent with merger control. It's good for the European Commission to just keep an eye on what's going on in the market, and see whether we have new gatekeepers that could fall within the obligations of the DMA. And also it's a good complement to the thresholds under Article 1 of the merger regulation. Now, the problem is Article 12 repetitive? Because if you go to paragraph 3 of Article 12, it sends you back to the notification that under Article 3, if you're a gatekeeper and you have met the thresholds. So if Article 12 is just a sort of notification for the sake of notifying that something will happen, then one doesn't see the value of having Article 12. You will have a notification at some point. So maybe Article 12 could be redesigned in such a way that makes a stronger connection with merger control. And actually, there are a few questions here that are not clear. Maybe the European Commission will clarify them. For example, how to apply the SIECT test to those cases, or whether in those cases you need the structural remedies because they are mergers that will affect the structure of the market, or if those mergers should be sent, for example, to a phase 2 investigation directly. And then finally, about the consistency when it comes to competition law. This is something that Professor Streel has already pointed out, which is about the aims, for example. So there we have the aim of the DMA, which complements competition law. So DMA is about keeping markets contestable and fair, and competition law is about protecting undistorted competition in the market. Then also the role of the member states is marginal there. I don't have any problem. Maybe some people do, but I don't see that. So there, for example, member states can only intervene in an advisory committee, which we have in Article 32. And then also under Article 33, we have that the member states can request a market investigation for designating gatekeepers. And then we have also in the recitals explained the hierarchy between the DMA and competition law. So the application of competition law articles cannot hinder the application of the DMA, and I think that's fine. Now, so from a point of view of static consistency, by that I mean at one point in time, I think all of these make sense. Now, the problem that I see is more about, I'm curious about what will happen when it comes to dynamic consistency, that is to say, the enforcement over time. So, for example, how this is going to affect the DMA, the powers of the national competition authorities to impose remedies. Will that be more limited, for example, because you may have incompatibilities there, because maybe the European Commission wants to do something and the national competition authorities want to do something else on the same undertaking. And also, if this, I'm concerned about how this is going to affect certain national competition authorities. Some of them have been very active in the past years on the application of competition law in the digital markets, and maybe they become more shy or timid to apply competition law. So maybe that's also an issue when it comes to the functioning of the European competition network. And also, for example, another question is, what if the gatekeeper gets a suspension of the DMA obligations? Will, for example, the national competition authorities be able to apply competition law to the same companies that have gotten that exemption? So these are just questions that we'll see how they are resolved in the future. So my conclusions would be that the DMA is not more of the same. I think it's a very interesting piece of work, and I'm really looking forward to see how it ends up. However, there are some few points that could be polished. So, for example, the instruments could be simpler. The interim measures need some refinement as well to be sharper. Then also the purpose of convenience is not clear, so maybe it's worth eliminating them. Also, the DMA seems a bit shy when it comes to remedies and maybe disappointed for some. And the Article 12 should be clarified, the relationship with merger control, and also the dynamic consistency, as I said, is still a mystery. So thank you for listening.
Thank you very much for this very insightful presentation, Alex. We will now hear a comment on both presentations by Mr. Bertin Martens. He's a senior economist and team leader for the Digital Economy Research Program at the Joint Research Center of the European Commission. His main areas of interest include online services, trade, copyright and digital media, data trade issues, and of course also the economics of online platforms. Bertin, we're now looking forward to your comment. Thank you very much.
Thank you, Nina, for this introduction. As you just said, I'm an economist, I'm not a lawyer. And so I will make some comments on the previous presentations from an economic perspective. My comments will be based on a report that was published a few weeks ago by my organization, the Joint Research Center. We assembled a panel of economic experts to give an opinion on the DMA. And so my comments will be focused on that. In view of the time constraints, I'll limit myself to 3 topics. The first one of which is enforcement, a bit in a follow-up to what Alex Ruiz just said. Again, these comments are from an economic perspective. So the question is, why do we have the DMA? And so in our economic interpretation, this is mostly due to the fact that there was an enforcement problem with traditional competition policy. It was considered inefficient, and several reports over the last 2 years have outlined that it's too slow, it's inefficient, because the remedies come too late or they are too weak. And an example that's often mentioned is the Google Shopping case. It took more than 5 years for the Commission to come up with a judgment in this case, and then the remedies proposed were very weak, and 2 years into the implementation of the remedies, we are still discussing whether they're working or not, and so on. So if we translate this in economic terms, what happens is that there's an information gap between the competition regulator and the platform. Platforms collect huge amounts of data, and the regulator doesn't have really access to all that. The regulator can ask for data from the platforms, but if the platform bombards you with a couple of terabytes of data, how do you analyze this? How do you go about this? What do you do with that? So how do we address this information gap problem? So the DMA has decided to overcome this information gap by replacing ex post remedies, the traditional approach, with ex ante obligation. And basically by eliminating the burden of proof. There is no burden of proof anymore on what is the relevant market. There is no burden of proof anymore on whether there's harm. They simply say, you are a gatekeeper, so you have to follow these obligations, period. Now, some obligations are easy to verify, whether you can download an app from another store or whether you can pay through another payment service, very easy to verify. But several other obligations are extremely difficult to verify. And that's where this information gap between platform and regulator comes. So, for example, Article 6A on refrain from using data, platform data against your business users on the platform, or Article 6D, refrain from self-preferencing in product search rankings. How do you verify that as a regulator? Now, the Article 5 obligations are probably much easier, but the Article 6 we consider to be much more gray obligations in the sense that it's much more difficult to come up with a burden of proof. Now, the Commission will say, these are obligations, period. There is no need for a burden of proof. But once you come to the Court of Justice, you will have to show your cards and show what arguments you have. Or even in the DMA regulations itself, it says that the platform can come up with arguments saying that there will be harm done to consumers or to end users. So there is some margin for coming up with burdens of proofs. So does the DMA approach eliminate this information gap? It does not. It does so to some extent, indeed, but not entirely. For example, it allows, it creates the possibility for embedded editors in platforms. But if you want to check whether there is still self-preferencing ongoing, you would have to run probably behavioral experiments with the algorithms of the platforms. The DMA does not say whether that is possible or not. Future practice will have to show this. And also, if you embed a regulator or an expert in a platform, how do you avoid regulatory capture of these experts and these auditors? So that's another, I think, very thorny problem that we'll have to find out how this will work in future. A second thing that I would like to talk about is the role of digital data in these platforms. Now, again, over the last 2 years, several reports have argued that the sheer volume of data collected by these platforms creates a competition problem because it allows them to enter into many markets, to dominate markets, to enter into adjacent markets, and so on. What the Economist report points out, and something that is not mentioned in the DMA, is that what is different in these digital platforms compared to traditional competition policy is that there are indeed probably welfare losses from monopolistic behavior by those platforms. But these should be balanced against the welfare gains from the network effects of these platforms. And the data that these platforms collect are essential to improve matching efficiency between consumers and sellers, or advertisers and sellers and consumers and so on. So if you try to eliminate or reduce those network effects or reduce data collection by the platform, you also create efficiency losses. And that is something that we want to avoid. Related to that, network effects can be strong, but of course they become much weaker if users can multi-home on platforms. And this is again something that is being omitted from the DMA for the time being. I suppose will be coming back in the discussions in the Parliament and the Council, but this is an important aspect, I think. In the expert report, this is discussed extensively, but just to mention one or two examples, there are lots of obligations for app stores, for example, that operating system app store operators should allow other app stores to compete with them, that app store apps should be available in an app store, in the Google Play or in the Apple App Store. But we have examples of competition between app stores. In the Android system, there's not only Google Play, there are several other app stores. Still, in most of the world, consumers go to the Google Play App Store, although there are others. And this is because of network effects. Now, there are consumer benefits of doing that. Do we want to eliminate those benefits? In China, we have, in the Android system, dozens of competing stores. And we observe there that this creates costs both for app developers and for consumers. Do we want to introduce a similar system in Europe? There are questions here, I think, that we should bear in mind. There are also obligations for search engines, for instance, to share their data. We've discussed this extensively in the economic report. There are economies of scale and scope in data aggregation, and that makes Google Search inherently a stronger, more efficient engine than Microsoft Bing, for example. If they will have to share data, Microsoft Bing may well catch a large share of the market, but does that mean that the efficiency in the market for consumers will remain high, or that overall efficiency will decrease? We don't have the answer to that question at the moment, but it's something that we should bear in mind. The bottom line here is data did not play a significant role in traditional competition cases or traditional utilities and sector regulations such as the telecom sector. But here in digital platforms, this is the main new phenomenon, and we don't have good answers here. Last point I wanted to make is going back to some old classic competition problems. I call this old analog wine in new digital bottles. Tying and bundling problems are well known from the last 50 years or more in competition policy. And so an ex-ante approach with obligations is useful to promote a number of contestability issues. And as Alex Streel pointed out, the main objective of the EMA is to promote market contestability. And so for that purpose, these obligations are very good instruments, we think. And we mentioned ancillary services, for instance, an Apple Pay on your Apple iPhone. You have to use Apple Pay. There are no other payment systems available. That's clearly foreclosure of the market by Apple, and the ex-ante obligations should get rid of that. Similar for subscription payments under apps and so on. And so that's why we say that tying and bundling practices should be presumed anti-competitive. But they should be gray listed, not necessarily blacklisted, because there should be a margin for proving a burden of proof on the efficiency of that. Welfare effects of these tying and bundling practices are usually ambiguous. They may be anti-competitive, but there may also be efficiency gains. And so therefore an efficiency defense is desirable, I think. For instance, the example of Amazon Prime. Amazon Prime, well, I take an example now outside Europe, in Latin America. Amazon Prime is not the main market, online e-commerce market. Mercado Libre in Latin America is a much bigger player. But so what is Amazon doing? It offers a bundle of Amazon Prime, which like in Europe or in the US contains free transport for anything you buy on Amazon, plus free access to its video streaming service. Now, bundling those two clearly has an advantage for consumers. They get two services instead of one. And so many consumers in Latin America are switching over to Amazon Prime because they get the free video streaming on top of free transport. Now, this is beneficial for consumers, but it creates a big problem for competitors of Amazon in the e-commerce market. And so here, this overall objective of promoting contestability, there's some tension here. Whose welfare should we be promoting? Consumer welfare? Then obviously this bundling is beneficial for consumers. Producer welfare? Then we may have problems about this. So this efficiency trade-off is something that we should bear in mind. I will stop here. My 5 minutes are up, I think, and leave the floor for comments and questions from others. Thank you.
Thank you very much, Bertin. I think it was really interesting for everyone to hear your economic point of view as well, as this is a topic where obviously economics plays a massive role. So I think it was very interesting for everyone. I think it is now time to move on to an open round of discussions. We have about 15 minutes left to do so. And I can already see maybe just a few remarks in the very beginning. I think Christiane mentioned it in her opening statement as well. So if you would like to participate in the round of discussion, you can either type the question in the Q&A chat if you prefer, then I will read your question or remark out, or you could also raise your hand and I will ask you to the floor and unmute you once it's your turn to speak. I can already see, maybe to start with, one question by Peter Bachmann. I'm not sure whether he would like to make an oral statement as well, but I will try to summarize his questions, which you can also find in the Q&A chat already. So he asked a very specific question, a very specific example already. He's currently working on, he asked a question on how a possible and also very, now that's a very common or very important topic as well. He's developing developed a website regarding vaccination passes online, and he had a question on how these digital identifier services might be impacted by the DMA. I already talked to Alexandre de Streel, who I think this question was pointed towards during one of the other presentations, and he said he would have to look into this very specific topic again, but he as I understood, he wanted to make a more general remark on identification services. So Alexandre, if you would like, you could make a remark now.
Yes, thank you very much. Thank you for the question. I need to dig a bit more on the specifics of the question, but there is two things which are important to mention here is because the role of digital identity and digital identifier could increase more and more. And so the question is how it is addressed in the DMA now. As you have seen the list of the eight digital services which are covered, digital identity is not in the list. Okay, so you cannot be a gatekeeper of you cannot be a regulated gatekeeper of a digital digital ID services. However, it is considered as an ancillary services, and there are some rules which relate to ancillary services in the DMA. And for instance, if you have a gatekeeper of one of the predefined in the list digital services which bundle that services with ID, with a digital ID, then that is prohibited by Article 5. So there are some, let's say, rules which relate to digital ID, but it's not considered as a main problem today. If I may, as I have the mic, if I could say, I just wanted to react on 2 points that Bertin made. One is on the welfare loss, welfare gain, and shouldn't we go a bit too far there? And in a way, it is taking a different stance from what I understand from the one of Alex, who seems to say, okay, it doesn't go far enough. Maybe we we would need to have structural separation more directly, while Bertin was coaching us and saying, okay, structural separation may not be, or having multiple services may not be the good solution. No, my reading of the text is that it doesn't push so much for having a multiplication of those provider of the same digital services. And so it doesn't push so much for an inter-platform competition. It is more, I think, opening the existing platform, and it's more an issue of intra-platform competition. So I think the Commission has understood very well that there is a lot of network effect and so on, and this is maybe why they were not pushing so much for structural separation, or they were not pushing, I don't read the remedy as pushing for an inter-platform competition. I see more for an intra-platform competition. And the second point, and it's more a question to Bertin, is you mentioned this trade-off between the consumer welfare and the producer welfare, and that's a standard trade-off. But my reading of the way this trade-off is approached is a little bit different, in the sense that it's more a question of long-term versus short-term. And the DMA, to me, favor long-term interest over short-term interest, but it's not necessarily it's not that the long-term are the one of the producer and the short-term are the one of the consumer. So I don't know. I mean, if we have time for not at another occasion, but I think those trade-offs are very key, and it's true that in the impact assessment or in the discussion are sometimes a bit very shortcutted, because there is this pressure of regulating and of doing something. We sometimes forget about those thresholds, and I think so. The report of the GRC, I really recommend everyone here to read it, because it's a kind of cautionary tale. But still, the question is whether it's a short-term, long-term, or producer versus consumer.
Can I briefly respond?
Yes, of course, of course. I don't see any other hands raised right now, so I think we do have time. Well, Alex would like to make a point afterwards, but I think, Bertin, if you want.
Yeah, Alex. So on this short versus long term, I agree with you. And so also when you go for the objective of contestability of markets, you basically want to allow new innovators to come into the market and so promote this long-term dynamic innovation process. And indeed, I think this is one of the underlying issues here. But the question is, how will this work out in the future? You can fragment the market by breaking it up in smaller pieces, and there will be more innovation, but whether that is really promoting welfare of consumers is an open question. And in particular, when we go to data, for example, data sharing issues. For example, we have the ongoing case in the PSD2, the Second Payment Services Directive, where banks have to open bank accounts to payment service providers. Question is whether in the longer run this will lead to more or to less market concentration. Will there be lots of smaller payment service providers that manage to get into the market? Or will it all be scooped up by Apple Pay and Google Pay and maybe 2 or 3 others, and that's it? And so we don't know. That's something we keep an eye on, have to be vigilant about. So the purpose of my comment was to say, let's be vigilant about it and not take it all for granted.
Yes, I think now, Alex, if you would like to make a point.
Yeah, it's just a question for Professor Streel. Actually, I kind of agree with both with Bertin and with Alexandre about, okay, there's no efficiency defense, so maybe you want to have something there. So, even though you, for example, reverse the burden of proof or the presumption, so you make it easier for the Commission, but at the same time you give some room to the gatekeeper to say, no, look, what I'm doing is sufficient. So, so you want have some leeway there, but I still don't see, for example, the point of Professor Streel about having a more principle-based list. Don't you think that will directly affect the aim of having the DMA at first place, which is having something that allows the European Commission to intervene quick? So because if instead of having rules, you have standards, which is more open textured standards, then that slows down a little bit the intervention. So you end up having a sort of duplication system, right? So because you have competition on the one hand, and then also the DMA, where you need still to do a kind of investigation and apply those open textured standards.
I'm not sure whether Alexandre would like to get back to this once more. Otherwise, we have another question from the floor. Sono Basca asked whether, or mentioned that trust and unfair trade practices are some major obstacles to the economy, obviously. And as we've seen vis-a-vis acute shortage of PPEs and ventilators during the initial phase of the pandemic, how could this regulate it, or I assume also how could the DMA play a role in tackling such issues? By the way, he also writes that he's a neurologist with an interest in digital health. So maybe if one of you would like to get back to this question, perhaps.
I can reply to both, and then I give the word to the others. But on the question of Alex, my point was not to say to replace the Article 5 and 6, so the detailed rule with more principle based, but it's to complement this Article 5 and 6 with a kind of Article 6A, which will have a more principle-based rule, but that will replace what we have for the one who followed the debate in Article 10, but basically this very broad possibility of adding new obligation after 2 years, after market investigation of 2 years, and on very broad criteria. So I would prefer to have something which is a little bit more frame, and but which can go quicker. So and for that, I think the model of the Unfair Commercial Practice Directive is a very good one. On the question that has been raised by Sonu, I think this is more related to what the DSA is aimed to do, and that is really to be sure that what you find on the internet, what you find on marketplace of internet, are safe product, that the marketplace knows where the product are coming from, and so on. So this is a very, very important issue, but this is an issue which should be covered for small and big marketplaces. And so I think this is addressed in the other instrument that will be discussed later, if I understood the question correctly.
I'm not sure whether any of the other speakers would like to refer to this very specific question. No. Otherwise, if I may, I don't see any other hands raised at the moment, and I also don't see any other questions in the Q&A, as I can see. But we do have another couple minutes, and if I may, I also wanted to ask another question, also basically referring to some of the aspects that were mentioned in your speeches already. I was wondering, so basically, as we mentioned already, so all the measures mentioned in the DMA, should they be, in your opinion, be a little bit more cooperative, like all of the commitments mentioned in the DSA already, or rather more adversarial, like in antitrust law? So where in this big sort of where do you see the DMA there? And also another question sort of related to this, if the measures should be more cooperative, does this mean that this completely excludes, for example, national competition authorities to support the Commission in their endeavors? Maybe one of you would like to make a stance on that.
Yeah, maybe I can say a few words. So, so essentially, you're asking whether about cooperation between the European Commission and then also gatekeepers, and then also the European Commission with other national competition authorities.
Exactly.
So I think regarding national competition authorities, I mean, to me, it's fine. Although the trend in competition law has been empowering the national competition authorities, so you can have today 27 authorities that complement the European Commission, who stays primus inter pares within the European competition network. And here it looks like it's going the other way around, but I think it makes sense because you're watching out a few gatekeepers not thousands of companies that could fall within competition law rules, but it's more about looking out what they do. So in that sense, it makes sense to have the European Commission there taking the lead. Although, of course, you may say, okay, for example, when it comes to what Bertin said before about control compliance, maybe national competition authorities can help out the European Commission in that sense if they have the expertise to say, okay, how are they, for example, implementing the obligation under Article 6.d, for example, as Bertin was saying. So maybe national competition authorities can have, a stronger role. But to me, it makes sense that the European Commission is taking the lead. And then about cooperation with undertakings, it would make sense to have that type of enforcement instead of having an adversarial type of enforcement. However, I think that's the purpose in the DMA. For example, if you read Article 7, the European Commission will be asking the undertaking, okay, what have you done? And this, if I think the European Commission thinks that they haven't implemented the measures effectively to comply with Article 5, for example, the European Commission then will impose more specific measures. And then also Article 25, I don't remember now what paragraph, but there also the European Commission can ask the undertaking or the gatekeeper, what are you doing? And then the gatekeeper can say, this is what I'm doing. So there are some ways where the DMA, I think, is trying to be more cooperative rather than adversarial, and I think that's also fine.
Thanks a lot, Alex. I would like to take one last question by Yannick Duller. It's directed to Bertin Martens. He has a question regarding the Payment Services Directive 2. Could it be argued, in your opinion, that by opening up the payment services to players outside of the banking sector, its objectives are already achieved? What do you think about this?
Yeah, thank you very much, Yannick, for this very good question. Indeed, you could argue, I think, that by opening up access to other payment service providers, the objective of contestability has been achieved. So there are more services that can enter into the market, and so it's become much more contestable. But this is my point on the objective of the DMA. Is it only contestability that we want to achieve? The question is, will this bring benefits to consumers? And as I said before, we may have a few large service providers like Apple Pay and Google Pay that sweep up the market and become the largest players because they get access to many bank accounts all of a sudden. And that may not be in the interest of consumers and may not be in the interest of some service providers. Which we should bear in mind. We have a very good example of this in Germany. There is the so-called Lex Apple Pay that was approved in January last year by the German parliament. And what that law was also about payment services, but on the Apple iPhone, where, as I said before, Apple Pay was the mandatory payment service provider on iPhones. But in Germany, Apple was forced to open it up to other payment services. And this was done mainly under pressure and lobbying from the German Landesbanken. Now, they lobbied very hard for this law. The law was approved in January last year. And then a few weeks after the law was approved, all of a sudden, these Landesbanken signed an agreement with Apple Pay to go ahead with Apple Pay services. So what happened? Why did they lobby so hard for this law? And when it was there, they didn't use it anymore. Well, the reason is simple. Network effects. If you go with Apple Pay, there's a well-known service all over the world in many countries, and there are many banks and many payment service providers that adhere to it. If you go with that, you immediately have access to a large network. If you, as a Landesbank in Germany, you want to promote your own payment service, well, good luck. It's going to cost you a lot of efforts to promote this. And so it was natural for them to go along with Apple Pay. Now, is this a bad or a good thing for the Landesbanken? I don't know. Nobody has studied the case. They will have to pay something to Apple Pay, a fee for the use of that service. But is this better or worse than what would they do normally? I don't know the answer. Is it good for consumers or bad for consumers? Again, it's a question to be evaluated. And so that's why I say these obligations of opening up are a good thing, but maybe we should not judge them only by the contestability effect. We should look at what are the consumer and producer welfare benefits for this.
Thank you very much for your answer. I hope, Yannick, this answers your question. Seeing that we're running quite short on time already, I would suggest we'll move on with a quick coffee break now. We will convene again at 3:10. So enjoy a quick break, and after the coffee break, we will get back and start discussing the DSA proposal. Thank you very much.
Thank you.